We're here for oral argument in the case of School District of Osceola County, Florida versus Cigna Health and Life Insurance Company. We just received notice about 10 minutes ago that counsel for the petitioner has filed a notice of voluntary dismissal with the court. It was filed, to my understanding, about 10 to 15 minutes ago. We were scheduled to proceed with the oral argument, and apparently counsel for the petitioner is not present for this proceeding. We understand that she indicated that she would not be here for this proceeding in view of having filed a notice of voluntary dismissal about 10 minutes before the oral argument. We are somewhat concerned with that practice, especially the fact that counsel has not appeared for the oral argument. In view of the notice of voluntary dismissal filed approximately 10 minutes before the oral argument, we will not proceed with the oral argument as scheduled. And we are especially concerned that Ms. Rolini did not appear for the oral argument upon filing her notice of voluntary dismissal approximately 10 minutes before the oral argument. I will defer to my colleagues if they have any additional input in the matter. No.
So, Mr. Lunny, on Friday, you filed the motion for us to relinquish jurisdiction because you thought you had it settled.
May I approach?
Sure, please.
Sure. Christopher Lunny for the Rady firm representing Cigna Health and Life, Your Honor. We filed, I think it was late last Wednesday, a motion to lift the stay so that Cigna could dismiss a petition below. It was not premised on a settlement. It was premised on the fact that the district had publicly procured contracts. The district had voted on May 3rd to enter into some agreements that the district had basically done an open and competitive procurement.
Okay.
And that was the relief that we essentially sought, was that the district would be required to competitively procure. So we filed that motion. At the time, the district took no position and intended to, told us that they didn't intend to file any response, and then we see the response for this today.
And you know, I think the reason that we weren't inclined to grant that at the time was because several times in this case, you all asked us to relinquish or to hold everything because you thought you were near a settlement, and then you were not. So we were prepared to go on oral argument. You know, if a notice of voluntary dismissal had been filed in a timely manner, I think that me and my colleagues would not have any real concerns. But since it was filed 15 minutes before we had an oral argument that we've all spent hours getting ready for, we're not really happy about that. And I don't really place that on you. I don't see that was your role. But I just wanted to get factually where we were.
Right, Your Honor. I mean, we prepared all weekend and today. So be that as it may, I mean.
Yeah, it would have been nice for you not to waste your client's time and your time also.
Would have been helpful.
Yes, that's all I have, Chief.
I was just going to ask you, I know in your motion, I think you advised that the petitioner took no position. Were you unable to get a response?
No, Judge, I actually got an email that indicated that they would take no position and that they did not intend to file a response. So there was communication, albeit limited and albeit hurried, in fairness to Ms. Rolini. It wasn't something that, you know, I had talked about for a week or whatnot. And so that was the response I got. Now, I can say that I think the first time that I learned today that the district was intending or exploring this option would have been like 12:30.
Well, we appreciate you being here.
Thank you, Your Honor.
I apologize for your wasted time as well as ours.
Thank you, counsel.
Yes, ma'am.
I don't have anything.
This concludes our session for this afternoon, and thank you, council, for your appearance this afternoon.
All right.